Welcome everyone to today's webinar on the New York HERO Act presented by Barclay Damon. Many thanks to our presenters Michael Sciatti and Brianna Cristiano for being with us today, and to all of our participants who have joined in. We'd also like to thank our educational series sponsor, Chemung Canal Trust Company. Please note this webinar is being recorded to share what we learn with the business community. All registered attendees will receive a link to the recording. Michael and Brianna will share their presentation with you, then follow with time for questions and discussion. Please use the chat to submit questions during the presentation. And just a reminder to please keep your audio on mute to minimize background noise. With that said, I'll turn things over to Michael to start things off.
Great, thank you, and good morning, everyone. I'm Mike Sciatti. I'm a partner at Barclay Damon. I'll be one of your presenters today, along with my colleague, Brianna Cristiano. We have a lot to go over. This should take about an hour. I will preface my comments by saying I don't think this is a big deal. I don't think this is crazy. I don't think it's going to be a heavy lift for you. I think it's new, and with newness comes questions. I think it's just a New York State pile-on with your obligations in the labor and employment world. But the timing of it's pretty good because we seem to be coming out of COVID, the lessons learned. The point of this law is for employers to be ready in the event something like COVID-19 happens again. As you will see, the state has hand-fed us a lot of stuff to the point where some of the documents are fill in the blank, and you have to tailor them to the specific risks that exist in your facility or facilities, but not a heavy lift. So, you know, we approach it from that, and there's some detail here. The detail is not overwhelming as it was with the COVID-19 leave laws. You know, I think we were all pulling our hair out very quickly because there was so much detail and it was overwhelming. That is not the case here. I put our contact information on these two slides. We will take questions at the end. However, if you have a question a day from now, a week from now, and you know, it's very generic, it's not super specific, you don't want us to look at documents, you know, feel free to email both of us, and one or both of us will get back to you, you know, within a day or so. I am also on Twitter and LinkedIn. I constantly post labor and employment and other updates in that regard. The agenda today, there's 5 specific areas we're going to cover. I'm going to cover the first 3. Brianna will cover the last 2. So we'll give you some general, excuse me, background information on the HERO Act. Excuse me. We will go over the HERO Act requirements for you and what you need to know now. We have some deadlines approaching. The first one is, you know, roughly 2.5 weeks away. The other one is the first week of September in that regard. So we'll go through the HERO Act requirements, give you some practical advice and guidance as to what we think you should be doing. We'll go over the Joint Labor Management Workforce Safety Committee. We have a little time for this one. I think it goes into effect the first week of November of this year. So you got a little time to get this one up and running. Then Brianna will go over the Employer Airborne Infectious Disease Exposure Plan requirements. The stuff that's in the plans, and you're going to see there is a generic plan and then 11 industry specific. A lot of it is lessons learned from COVID. Wash your hands. You use a hand sanitizer with 60% alcohol. Disinfect the surfaces. Wear PPP if needed. What is the appropriate PPP? Nothing radical. Coming out of COVID, hopefully everything in there is going to seem second nature to you. They just want you prepared in the event this happens again. What is an amendment to the labor law or an addition to the labor law without the ability of your employee to be able to sue you? Of course they can sue you. They will have two remedies. They can file a complaint with the Department of Labor, or they can file a lawsuit in New York State Supreme Court. And Brianna will go over some of the issues involved in that. So that's really what we're going to talk about for the next hour or so. But I'll start out with some general background. The HERO Act was signed into law back on May 4 of this year. It adds section 218-b of the labor law. In case you want to go look it up, we're not big in giving you a lot of legalese on these webinars, but I do like pointing out what the section is in case you want to go look it up. They realized after passage, they made a few mistakes in the law, and they passed a series of amendments on June 11th. Those went into effect. The state of New York has created a HERO Act website. I've given you the link there. We will, in a minute, be going reviewing for you the model plan and listing for you the industry-specific plans. All of those can be found on the HERO Act website. I believe they're in PDF format. You can easily turn around and convert them to Word document, edit them, and make it like, take it and make it your own. On July 6th, the Department of Labor published a couple items, three specific areas. Number one, the Airborne Infectious Disease Exposure Prevention Standard and the Model Airborne Infectious Disease Exposure Prevention Plan. Brianna will talk a lot about these plans, but again, they're hand feeding us the stuff. Don't sweat it. You do have to read it. It's going to take you half a day to get in compliance. Let's do it. And then more importantly, they gave 11 industry-specific model disease prevention plans. If you are in one of the construction or manufacturing, you're going to have to tailor it and make it your own in that regard. But these are all meant to be your starting point. Mike, can I disregard these 12 plans that the state of New York has created and create my own? Yes, you are not required to use one of the 12, but I would encourage you, hey, this is what they want it to look like. Use this as your starting point. Tailor it to make it specific to your business. Otherwise, if there's a administrative complaint or a lawsuit, you're going to have to prove that your plan was timely adopted and that it was legally sufficient. That will be your burden. If a civil administrative claim is filed, you could be fined up to $20,000 in the event your plan is not up to snuff. And there's a second violation fine, but it's $10,000 for the first violation, up to $10,000 for the first violation, up to $20,000 for the second. Given the fine levels that we're seeing, we're encouraging just use the state's starting point, tailor it to your specific business. I mentioned a minute ago the 11 specific industry-specific plans. I've listed them here for you. Agriculture, construction, delivery services, domestic workers, emergency responders, food service, manufacturing and industry, personal services, private education, private transportation, and retail industries. Now let's use a little common sense. Manufacturing. Are all manufacturing facilities the same? No, they're not. Are all construction businesses the same? No, they're not. So you're going to have to tailor them specifically to your business and the risks associated with what you do and the reality of it, which quite frankly, the lawyers aren't going to know. The lawyer's part in this process is to maybe review your plan after you have developed it, maybe explain your legal obligations to you, and to ultimately defend you later on. It's just that the state made it simple for you. Let's not overthink it. The other thing you're going to be able to do is you have COVID plans in place. A lot of what's in your COVID plans you're going to see are in the one of these plans. So you're going to be able to use a lot of it. Mike, you mentioned the safety committee. I already have a safety committee. Can I make that safety committee what you're about to talk about in a few minutes? Yes, you can. No big deals. Don't make it more difficult than it has to be. I've given you a couple of attachments. I have not attached the 11 industry specific plans. You can go to the website for that. I have attached the model plan, and I have attached the airborne infectious disease exposure prevention standard, both of which are very similar in format, and Brianna will be going over. Now, the most important question in an employment law, which is what this is, it's in the labor law, is am I a covered employer? Are my employees covered employees? So there's a lot of slides here that follow, but let me make it nice and simple for you. If you are in the private sector, you are covered by the HERO Act, period. It doesn't matter if the employees are part-time, full-time, temporary, seasonal, makes no difference at the end of the day. The rule will change slightly when we get to the safety committee, and we'll deal with that when we get there. The definition is not necessarily the same. However, that is the rule for the HERO Act in general. So a covered employee is anyone working in the private sector, regardless of their immigration status. It includes, like I mentioned, part-time workers, but this one is one of the shockers to me. It includes your independent contractors. So this is an example of a labor law provision using the term employee to include your independent contractors. Please be aware of that. It also includes domestic workers, home care workers, personal care workers, day laborers, farm workers, temporary workers, and seasonal workers. They were so detailed, I think, because they don't want anyone to say, well, what about me? If you're in the private sector, you're covered if you have an employee. They felt the need to do this. I thought the definition was clear. They added some additional detail. It also includes individuals working for digital applications or platforms such as apps, maybe on your iPhone, staffing agencies, contractors and subcontractors on behalf of an employer at any individual work site. The statute does define the term work site. We're going to give you that in a second. A covered employee also includes any individual delivering goods or transporting people on behalf of the employer. The term does not include, and this is fairly typical, believe it or not, the government has excluded themselves from a covered employer and covered employee. If you work for the state or any political subdivision, you are not covered by the HERO Act. This is something they have dumped on the private sector and the private sector only, such as wage theft, the wage theft form. That's a private sector only requirement. The statute also defines the term employer. It doesn't matter what type of entity it is. Let me be frank. Sole proprietor corporation, LLC, LLP, a limited partnership. It doesn't make a difference. The industry, trade, business, or service you are providing doesn't make a difference. So regardless of what the entity is the employees work for, that entity, if it's in the private sector, is in fact a covered employer. To close the loop, they also define an employer as not including the state or any political subdivision thereof. Don't shoot the messenger. Complain to your state senator and assembly person if you don't like the fact that the government excludes themselves from these laws. I mentioned a minute ago, the law also defines the work site. Some of you only have a physical location. Others of you in construction. Wow, we've got all our vehicles. Our vehicle is a work site. We have we send our construction workers out into a field and they could be working on 10 different projects. Those 10 different projects are all work sites, and you need to keep that in mind. So the work site includes any physical space, including vehicles that have been designated as the location where work is to be performed, or over which the employer has the ability to exercise control. Not that you definitely do, it's just simply the ability to do so in that regard. All right, we have one question. Question, assume not-for-profit is considered an entity employer and is subject to the HERO Act. Is that correct? Absolutely. That is correct. The private sector, not-for-profits are covered in employers. They are considered in the private sector in that regard. A work site also includes employer provided housing and employer provided transportation to and from the work site. The work site does not include the residence of the employer or the employee unless the residence has been provided by the employer and is used as the primary place of work. A work site also does not include a residence provided to farm workers under a specific provision of the New York State labor law. The law also will deal with the term supervisor. Who is a supervisor? It is not limited to individuals who actually supervise people. You have individuals who are managers that don't manage anyone. They handle a specific area. You know, sometimes some of you maybe only have one HR person, the vice president of HR, the director of HR, regardless of what the title is. They are an exempt employee and they handle all the HR issues, and that's all there is based on the size of the company. They don't manage anyone. That's fine. They're still going to be a supervisor. The term supervisor or a supervisory employee means one of the following. All you need is one. You have the authority to direct and control the work performance of other employees, or two, you have managerial authority to correct a violation of laws, rules, or regulations. So it's very broad in that regard. Some of you probably have what I call quasi-supervisors, like a shift supervisor where they tell people what to do, but they can't hire and fire in that regard. That person's a supervisor under this law. They don't have to have the ability to hire and fire. The term shall not include any employee who's a member of the collective bargaining unit in that regard. You know, just beware. I think it depends on the unit. You know, some units may have these quasi supervisors in them, but that's the general rule. It doesn't include anyone usually covered by a CBA. The term airborne infectious disease is used throughout this. You know, it's a two-part process. So we don't want the common flu to get caught up in this, in my opinion. So that's how they define that. It's a two-part. Part one, the airborne infectious disease is any infectious viral, bacterial, or fungal disease that can be transferred through the air in the form of aerosol particles or droplets. That's part one. Part two is the New York State Department of Health must designate whatever that disease is as, quote, a highly contagious communicable disease that presents a serious risk of harm to the public health. So you need both in order for this to be triggered at the end of the day. Now, as we move forward here, I want you to keep in mind two different parts to the law. What are your initial obligations? And then what will your obligations be if an airborne infectious disease is designated by the Department of Health in the future? The goal here is that you have something ready right now. So we're about to tell you what to do right now to have it generally ready. And then Brianna will tell you what you need to also do in the future if this designation occurs by the Department of Health. You're going to have to review your plan that you have in place immediately, make revisions to it, and she'll walk you through it. So remember, this is a two-part law. What we must do right now and what we must do in the future in the event there's a DOH designation of this. My guess is it would be something like COVID. All heck is breaking loose. You're going to know about it. There will be emails coming out from the Department of Labor, the Department of Health, and all that. And it's going to be a very newsworthy issue. So please keep that in mind. Two parts to this: what you do now and what you do in the future. So I'm going to talk to you about the HERO Act requirements for now. What are the requirements of the plan? Employers must adopt and implement an airborne infectious disease exposure plan in general, okay? We're not dealing with a specific one as of right now. Who knows what will happen with this Delta variant of COVID. The COVID numbers are creeping up again. You know, I saw something on the White House's website that they're considering reinstituting some type of facial ban, facial requirement. We'll see whether that morphs into anything. So right now you must adopt, I'm going to give you the deadlines in a second, this plan, and step two is give it to your employees. We have to roughly the first week in September to give it to your employees. You also must post it with your other employment posters at the work site, and you must incorporate it into your employee handbook. I recommend that you do it as an appendix as opposed to like physically, you know, like making it its own section. Why? Because it could change over time. And I think the easiest, most practical way that I can tell you it's helpful is simply have it as an appendix, revise the appendix. You don't have to revise the whole handbook in that regard. Can you put it in the handbook and not make it an appendix? Knock yourself out. You're in compliance if that's what you want to do. And the plan must be available for review. And you're like, well, wait a minute, Mike, you just gave it to the employees. How many of your employees are going to lose this or destroy it 5 minutes after they get it? A fair number, I would imagine. 6 months from now, an employee comes to you and says, I don't know where my copy is. Can I have another one? Yeah, give them another one. The Department of Health, the Department of Labor comes knocking. We want to see your plan. They have the right to see it, and you're going to have to produce it. So that's sort of what that means in this regard. Again, I've already mentioned you're free to adopt your own plan, an alternative plan, but it must meet or exceed the state's requirements. Knock yourself out if that's what you want to do. I think from a practicality, a cost-benefit point of view, that you start with the state's version and you make it your own in that regard. If you have the pleasure of having a union, you must develop the plan in conjunction with a collective bargaining representative. If there is no group per se, a union per se, the alternative plan must be developed with participation of employees in the event there's no bargaining unit. So you can, you'll have to get your employees involved in the event you want to go at your own in that regard. So it's probably easier you just adopt the state's plan and make it your own. Mike, can I get my employees involved on our initial plan? Can we get the safety committee involved? Sure. There's no problems with any of those things, but you have to do it, and you have to do it fairly quickly. And here's our deadlines for getting in place the plan and distributing the initial plan to your employees. You have to do it. You have to adopt the plan within 30 days after the DOL published their standards, which was on July 6th. So we have roughly to August 5th to conclude that process. You then have another 30 days, which takes us to roughly, I think early September, to distribute it to your employees in that regard. So your first deadline's coming up. It's August 5th. You have to adopt the state model or establish your own, which meets or exceeds. If you're in the private sector, including not-for-profits, all of you, this is your first homework in that regard. You get all of the plans. I gave you one, but you can get all of the plans, including the industry-specific ones, off the website, which I gave you the link to early on in the presentation. Okay. Now let's talk about the Joint Labor Management Workplace Safety Committee. We have until the first week of November to do this. It's another provision of the labor law, section 27D. Unlike the HEROES Act, this applies to employers employing at least 10 employees in that regard. So it's a little different, not much. I think they wanted to exclude the smaller companies and not make them go crazy in this regard. Do I automatically have to establish one of these committees, or do I have to wait for one employee to say, I want a committee? You can wait till one employee says, I want to establish one of these committees. You don't have to. You can do it automatically. You can volunteer it in that regard. I think a lot of good can come out of a safety committee if it's properly run and managed in that regard. Are we 100% sure that you don't have to automatically establish it? No, I think we're about 95% sure you don't have to automatically establish it. The language is a little goofy, but you know, I think it's a safe bet. An employee must ask, and I think it's just one. And I think that's the trigger. If you're covered by this particular law, the committee must have at least 2/3 non-supervisory personnel in that regard. The employee members are to be selected by and from the non-supervisory employees. The management members can be picked by management. The collective, if there's a union, the union will be responsible for picking the employee members, and there will be 2 co-chairs, a management co-chair and a non-management co-chair at the end of the day. The committee is authorized to do the following. Now, once we go through these next few slides, there's really no more detail to give you. It becomes the wild, wild west. How many people have to be on the committee? Are there term limits on the committee? None of those things are covered in the law, so I think it's whatever you want in those regards. But the committee is authorized to do the following: raise health and safety concerns, review policies relating to occupational safety and health, review the adoption of policies in response to health and safety laws, participate in site visits should the government come knocking, such as OSHA, to do some inspection. The entire committee can accompany OSHA on the inspection. The safety committee is also authorized to do the following: review reports filed by the employer related to health and safety. That could be your OSHA log at the end of the day. Please remember, non-supervisory, depending on what the committee's doing, non-supervisory employees cannot review the medical records of other employees. They are simply not authorized under the ADA in that regard. A question that has popped up: if we create a committee voluntarily, do we have to let an employee join it if they ask to? No. If you are covered by this law, or if you are not covered by this law, I should say, and you want to do it voluntarily, you don't have to allow someone to join if you want. My guess is you probably have a rabble-rouser or someone that you view as a pain and you don't want them on the committee. I have no problem with excluding them if you don't have to comply with this law. If you do have to comply with this law and that individual is voted on, you're stuck with them. Now, you as an employer, I think you can do 2 term limits, meaning, yeah, your limit on the safety committee is 1 year and then we're going to turn it over. Okay, I think that's fair, and I'm pretty sure it's going to be legal. So review the reports, but make sure depending on what the committee's doing, they are not reviewing medical information of employees. And if for some reason they are, it needs to be redacted. All identifying information of the employees must be removed. The safety committee must have regularly scheduled meetings at a minimum of once a quarter. I think I'd recommend to you every month. And you can set a time limit, max 2 hours in that regard. The employer must permit safety committee designees to attend training at a maximum of 4 hours without loss of pay to the employee. All right, so those are the first three parts, and I'm going to turn it over to Brianna in a second, but we'll come back and we'll answer questions. So with that, I'm going to mute myself, Brianna, and you should have control.
Thank you very much. Good morning, everyone. So I'm going to pick up with discussing the recently released standard by the Department of Labor. They call it the Airborne Infectious Disease Exposure Prevention Standard. It's a mouthful, but we'll go through the things that they have said are required to be included in the standard. And as Mike said, they also include some exposure prevention standards that are going to have to be implemented if the Department of Health ever deems an airborne infectious disease that is required under the HERO Act. So we'll go through what they say. A lot of them are, at this point to us, commonplace and very obvious after COVID. So again, this applies to employers with work sites located inside of New York State, and it applies only to an airborne infectious agent or disease designated by the Department of Health as highly contagious communicable disease that presents a serious risk of harm to the public health. It does not apply to employees or independent contractors of New York State, as you know. And it also does not apply to any employee within the coverage of a temporary or permanent standard adopted by OSHA regarding COVID-19 and/or airborne diseases, or any seasonal or endemic infectious agent or disease that has not been designated as a highly contagious communicable disease that presents a serious risk of harm to the public. Now, as far as this is concerned, the Department of Health website indicates that there is nothing identified at this point, and while you need to check, it'll be pretty obvious when the time comes when health that would then trigger the HERO Act requirements. So each employer has to establish a written exposure prevention plan, which is designed to eliminate or minimize employee exposure to airborne infectious agents in the event of an outbreak. As you know, employers are either able to develop their own plan or adopt one of the exposure prevention plans that has been provided by the Department of Labor. So you can either take the time to create your own or just modify the ones that have been provided by New York State. Okay, and so Mike alluded to this earlier, but employers are required to work with a collective bargaining representative, if there is one, on creating the exposure prevention plan. If there is not a collective bargaining representative, then you're required to work with the meaningful participation of employees where there is no collective bargaining representative for creating the plan, including tailoring it to the specific hazards of the industry and work site. Okay, so the exposure prevention plan has to incorporate any applicable work sites as appropriate. And so to do this, the easiest thing to do is to look at the industry specific model templates that the Department of Labor has given us, find the one that most closely resembles the work site that you're making the plan in regards to, and tailor it from there to the specific requirements. Okay, so each employer has to make request of
Brianna, you froze on us here.
Not independent of that.
Brianna, you froze up on us on that
Okay.
slide. Not
Okay.
quite sure where you left off. If you maybe want to just start that one over. Sorry.
Sure, sorry about that. As you know, the great thing about technology is that it works until it doesn't. So I'll just go over this slide again.
Thanks.
So for the exposure prevention plan, the employer is only required to make the plan available upon request. And so any of these parties, employees, employee representatives, collective bargaining representatives, independent contractors, and state agencies can request the plan, and the employer is required to provide it. But until any plan is required to be implemented and be used, you don't need to provide it if not. Okay, so in the event that the plan is required to be implemented, so the Department of Health says this is an airborne infectious disease that is highly contagious and we're designating it, and the HERO Act goes into effect, and the exposure plans are required. At that point, the employer is required to conduct a verbal review of the employer policies, employee rights, and the employer's exposure prevention plan. And so when you do that verbal review, it needs to be provided in a manner that's most suitable for the prevention of the airborne infectious disease. And we're all familiar with this. It may be in person with PPE, face masks, or via video technology like we're doing now, if that's what's most appropriate. Okay, so when a highly contagious communicable disease is designated by the Department of Health as presenting a serious risk of harm to the public, the employers are required to immediately review the exposure prevention plan that they had prepared beforehand. So the one that you're working on preparing now, you're gonna have to look back at it, make sure that it incorporates anything current. So as you know from COVID, laws, orders, local ordinances were constantly changing, and the requirements were constantly changing. So if a airborne infectious disease is designated, then you have to just take out the plan from the top of the shelf, dust it off, look at it, and make sure that it still is in compliance with what's happening now and it's appropriate. Okay, so from there, you need to finalize and promptly activate the exposure prevention plan. And then you're going to do the verbal review that we talked about before. So where you sit down with employees and discuss the exposure prevention plan and their rights under the same, and you know, that can be done in person, that can be done virtually, whatever is most appropriate at the time. And at this point, you need to provide each employee with a copy of the exposure prevention plan. Also, you need to post a copy of the exposure prevention plan at the work site and ensure that a full copy of the plan is available to employees during any shift. So in addition, the HERO Act requires employers to regularly check the updated information and guidance provided by the Department of Health, the CDC, and any other agency that's concerning the airborne infectious disease, and updating the plan when necessary so that it does reflect the recommended control measures. In addition, a covered employer must also designate a supervisory employee to enforce the compliance of the exposure plan, the HERO Act, and any other applicable standard regarding the spread of the infectious disease. So make sure that your company has a point person who's really going to take the lead on making sure that they're familiar with the prevention plan and they're keeping up to date with editing it and revising it as necessary and implementing it at the work site. No individual who is not a supervisory employee shall have the responsibility for overseeing compliance with the plan. So if there's a lower level employee who would be really great for this, they're not going to be a fit under the HERO Act. It has to be somebody that's designated as a supervisory employee. The employer has to select and obtain appropriate exposure controls based on the types of and levels of exposure risks performed at the work site. So the Department of Labor standards require that the following controls need to be included in the exposure prevention plan. So we're going to go through them, but many of them are things that we at this point are familiar with from COVID. And so this is going to sound like things that you're very familiar with, But in the event that the exposure plan is required to be implemented at the site, these are the things that employers are required to use. So daily health screening at the beginning of each workday in accordance with the guidance used by the Department of Health and the CDC. Employers have to limit the exposure of other individuals to employees demonstrating any symptoms. Employers shall follow the Department of Health and CDC with isolation, quarantine for employees demonstrating any symptoms before they return to the work site. And also for informing other employees who may have been exposed about what's going on. They also require face coverings. So employers are going to be required to provide appropriate face coverings deemed appropriate by the Department of Health and the CDC. And they're going to be also required to make sure that employees are wearing appropriate face coverings in the event that physical distancing is not able to be implemented. And as we're familiar with at this point, physical distancing should be used in terms of keeping employees at least 6 feet apart from other individuals or whatever at the Department of Health and the CDC is recommending. Okay. The employer shall have hand washing facilities available, and if that's not possible or practicable, they're required to have hand sanitizing facilities. And it even goes so specific as to say what the specific composition of the hand sanitizing is going to be. So they're saying at least 60% alcohol. So for these very specific standards, you can certainly just refer back to the Department of Labor website to make sure that you're implementing it correctly, but that is there. Okay, employers shall determine and implement appropriate plan for cleaning and disinfection that includes methods based on decontamination. So the location, facility type of services to be cleaned, type of material presented, this determines kind of the level and manner of disinfection that you should use at the work site. And they direct the surfaces known or believed to be contaminated with infectious materials have to be cleaned soon as possible. And any surfaces contaminated with dust or other loose materials have to be wiped. And any of the frequently touched surfaces such as handrails, doorknobs, elevator buttons have to be disinfected through the workday pursuant to whatever the Department of Health or CDC recommend. In addition, any shared tools or equipment or workspaces need to be disinfected. And common areas such as bathrooms, dining areas, break rooms, locker rooms, vehicles are going to need to be cleaned and disinfected at least daily. In addition, there may be some requirements about PPE. We know at this point that PPE may be necessary for the protection of an employee, and it has to fit the employee. It shall be maintained in a sanitary and reliable condition at the expense of the employer. So the exposure prevention plan needs to put the burden on the employer to maintain and sanitize any of the PPE that employees are required to wear. So the employer needs to provide and require employees PPE and any other protective equipment that's necessary. And they need to provide training on how to use the PPE for employees. And where employee-owned PPE is used at the work site, the employer shall be responsible for ensuring that the employee-owned PPE is adequate and is working correctly in the way that it's intended to work. So all PPE, including employee-owned PPE, has to be stored, used, and maintained at the work site in a sanitary and reliable condition. So as opposed to, the beginning of COVID when it wasn't clear as to who had the burden to purchase PPE, make sure it's fitting correctly, make sure there's an available stock of them in case additional PPE is needed. We know now that if there's a future exposure prevention plan required to be implemented, then the employer is going to have the burden to cover all of that. So be prepared to do that. Okay, in addition, the HERO Act does have anti-retaliation provisions available to employees. So employees are going to be protected for exercising rights or reporting violations or concerns under the HERO Act. So rights are going to include refusing to work where an employee reasonably believes in good faith that work exposes either the employee, coworkers, or anybody else to unreasonable risk of exposure due to conditions that are inconsistent with the applicable law. So the Department of Labor's Anti-Retaliation Unit is going to go in and inspect if there is any complaint by an employee of failure to comply with the law, and if there is found to be a failure to adopt an exposure prevention plan, then those penalties can be assessed as $50 per day. And if there is a failure to follow an exposure prevention plan found by the Department of Labor, then the fine can be up to $10,000. Now, if there is a finding that within the previous 6 years, the same employer has violated any of the provisions of the HERO Act, then the failure to adopt the exposure prevention plan can be up to $250 per day, and then the fine can go up to $20,000 a day. So if you have a violation that's been found by the Department of Labor, be really cognizant of the increased exposure if another one is found. In addition to those fines by the Department of Labor, an employee can also bring a private lawsuit in New York State Supreme Court. So an employer can bring civil action seeking injunctive relief against the employer alleged to have violated the exposure prevention plan. And in order to establish their case, the plaintiff, in this case, the employer, is going to need to establish that the violation created a substantial probability that either death or serious physical harm could have resulted to the employee from the condition that existed at the time. And in addition, the employee is going to need to establish that the employer had notice of that condition. So the employer can defend itself by showing that they did not and could not, with the exercise of reasonable diligence, know of the violation of the exposure prevention plan. And these are the employee's remedies with regard to a violation of the HERO Act. So they can either get an injunction against the employer, they can get attorney's fees if they prevail, and any other appropriate remedies. If a lawsuit is deemed frivolous, attorney's fees can be assessed against the employee for bringing the lawsuit and their counsel, depending on the facts. In addition, the employee, before bringing a civil action, has to give the employer notice of the alleged violation. So they have to bring their complaint to the employer, and the employer then has 30 days from the date of the notice by the employee to cure the violation. And the employee can only bring their civil lawsuit if they establish that the employer demonstrated an unwillingness to cure the violation in bad faith. Okay, the statute of limitations is short on this. So an employee has to bring a civil action within 6 months from the date that the employee had knowledge of the violation. So that's the date that starts their clock running. Okay, so that's the end of our PowerPoint now. So I'll turn it back over to Mike to address any questions that may have come up.
Okay, I don't see any questions. You're free, everyone, to ask questions at this time if you wish. If you don't have any and you think of one in a day or so, again, feel free to email us. But keep in mind the initial plan, early August, the distribution of that initial plan by early September. The safety committee, you know what you have to do if requested. That's on or after the November date. You can do it ahead of time. Remember, two-part process, what you have to do now and what you have to do in the future in the event we have one of these airborne diseases is designated by the Department of Health. And you basically have to just revise it, distribute it, train your employees on it, as Brianna has indicated, but you at least have something to start with. Okay, we got a couple questions. Do we have to distribute in September if there has not been a designation? Yes. The initial one, when I went over, got to post it, distribute it to your employees. It is just basically, here is our general policy in this regard in the event this occurs, and we will revise in the event there actually is an update. What training is recommended when this is initially put in place? I would simply review it generally with the employees. I think there was a slide indicated in there, a verbal review. It's basically, hey, this is our model in that regard. In the event we actually have an airborne disease so designated, we will revise it, distribute it, and then do another verbal review, which I refer to as training. And that would be the more important one. You could throw this in. Some of you have training days or training half days. We have to do the sexual harassment prevention training in New York every year. You could simply put this in and anything else that you are required to train on or that you think is important. I'm a big believer in training on the handbook every year, getting the sign-offs. You can do it all in one session. It's really up to you in that regard. Any other questions? Okay, so Brianna, anything else you want to add at this point?
No, I think you've covered it.
Okay, well, great. Thanks, everyone. Again, this is not a heavy lift. Please start with the state's model. Again, two-step process. One step you got to do now. In the future, you may never have to do. There may never be a designation in that regard. Also, since it's safety related, always a good time to take a look at your handbook to make sure it's up to date, get your safety policies up to date, etc. And another question has popped up. Will we be getting a copy of this WebEx? I will let the chamber answer that, and I'll turn it back over to the chamber at this time.
Thanks, Michael, and thanks, Brianna. Yes, you will receive a link to the recording later today. And again, as Michael mentioned throughout this, if you have any questions now, later, you can reach them directly or always shoot us an email and we can help connect you. But with that said, thank everyone again for joining us and have a great day.
Thanks, everyone. Take care.
Thank you.